Your Honor, the man sitting in that prison cell has been there for 18 years. He was 22 years old when they took him. He is 40 years old today. And the real killer confessed to a priest 9 years ago. The courtroom did not move. Not one person. Not the prosecutor. Not the court reporter. Not the 3 journalists in the back row who had covered hundreds of hearings between them and believed they had developed the professional discipline to remain neutral in the face of anything a courtroom could produce. Judge Raymond Ellis looked down from the bench at the attorney who had just spoken. She was a woman named Carol Briggs, 54 years old, silver-streaked hair pulled back, reading glasses pushed up on her forehead, a worn leather satchel on the table in front of her that looked like it had been carried into courtrooms for 20 years. She had taken this case 11 months ago pro bono after a college student named Maya Chu had walked into her office with a cardboard box and said, "I think an innocent man is going to die in prison and I cannot get anyone to listen to me." Carol had listened, and now she was standing in a post-conviction relief hearing in the same courthouse where 18 years ago Marcus Webb had been convicted of a murder he did not commit, holding a file that contained a signed affidavit from a Catholic priest named Father Daniel Okafor, who had carried the confession of the real killer in silence for 9 years, until his own conscience had finally become heavier than his obligation to the seal of the confessional. Judge Ellis said quietly, "Ms. Briggs, are you telling this court that the actual perpetrator of this crime confessed to a member of the clergy and that this information has been available for 9 years?" Carol said, "Yes, Your Honor, that is exactly what I am telling this court." The silence that followed lasted 6 full seconds. Then Judge Ellis said, "I think everyone in this room needs to hear the full story. Ms. Briggs, from the beginning. Stay. Right here. Subscribe to Sweet Justice right now. Because what Carol Briggs uncovered in 11 months is something that the entire justice system missed for 18 years. And the way she found it will change the way you think about what the right attorney can actually do." Marcus Webb had been 22 years old in the spring of the year his life ended. He was a quiet young man from the south side of Chicago, not remarkable in any particular way that the world tends to reward, but remembered by everyone who knew him as decent, steady, and hard-working. He had been working 2 jobs at the time of his arrest, a morning shift at a warehouse and an evening shift at a grocery store, saving money to take night classes at a community college. He had no criminal record. He had no history of violence. He had, by every account of the people who knew him, no conceivable reason to do what the state of Illinois said he had done. The victim was a man named Gerald Pope, 44 years old, a mid-level manager at a financial services company, found in his car in a parking garage on a Thursday evening in April with evidence that he had been the victim of a robbery that had turned fatal. His wallet was gone. His watch was gone. His briefcase had been opened and rifled through. He had not survived. Marcus Webb had been identified as a suspect through a single piece of evidence, an eyewitness, a woman named Patricia Dunn who had been in the parking garage that evening and who told police she had seen a young black man running from the direction of Gerald Pope's car approximately 10 minutes before the body was discovered. She described his height, his build, his jacket. She said she had seen his face clearly under the garage lighting. 3 days after the incident, Patricia Dunn was shown a photo array. She identified Marcus Webb. She was certain, she said. She had no doubt. Marcus was arrested the following day. He told the police he had been at his evening job at the time of the incident. He had been clocked in. He had a supervisor who had seen him. He had co-workers who could confirm he had never left the building. The alibi was documented and corroborated. His defense attorney, a court-appointed lawyer named Harold Sims, who was carrying 46 active cases at the time of Marcus's trial, and who had met with his client a total of 4 times before the verdict, presented the alibi evidence to the jury. The jury deliberated for 2 days. They convicted Marcus Webb of felony murder. He was sentenced to life in prison. What happened over the following 18 years was not dramatic. It did not involve last-minute appeals or high-profile advocates or documentary filmmakers. Marcus Webb sat in a prison in downstate Illinois and filed motions, through Harold Sims initially and then through a series of legal aid attorneys, that were denied one after another. He maintained his innocence consistently and completely. He became, in the vocabulary of the prison system, a model inmate, not because he had given up, but because the only thing he could control was himself, and he controlled it with everything he had. Outside the prison, nobody was paying attention. Gerald Pope's family had received a conviction and a sentence and had, over time, done what grieving families must do. They had tried to move forward. Patricia Dunn had moved out of Chicago 6 years after the trial and had not been involved in any subsequent proceedings. Harold Sims had retired. The case had become, in the filing systems of the justice system, closed. And then Maya Chu had opened a cardboard box. Maya was 20 years old, a junior at the University of Illinois studying criminal justice when she was assigned a semester project on wrongful convictions in Illinois. She had gone to the state archives and pulled 10 cases at random, looking for one that would make a good paper. The Marcus Webb case had been in the pile. She had started reading it on a Tuesday afternoon, expecting to spend an hour on it. She spent the next 3 weeks on nothing else. What Maya found was not a smoking gun. It was something more subtle and more damning than a smoking gun. It was a pattern of small failures, each one individually explainable, collectively catastrophic. The eyewitness identification had been conducted using a photo array procedure that Illinois had since reformed due to documented reliability concerns. The array had been administered by a detective who knew which photograph was the suspect, a practice now understood to risk unconscious suggestion. The alibi witnesses had been interviewed by the defense attorney for a combined total of 40 minutes before trial. The physical evidence from the crime scene, fingerprints lifted from Gerald Pope's car, fibers found on the driver's seat, had been logged and filed but never forensically compared to Marcus Webb or to anyone else. It was still in a state evidence warehouse, untested for 18 years. Maya had written a paper that her professor had described as the best undergraduate work he had read in 11 years of teaching. He had also quietly given her the name of Carol Briggs. Do not go anywhere. Subscribe to Sweet Justice if you have not already. Because what Carol found when she walked into that evidence warehouse is the moment this story changes everything. Carol Briggs had spent 26 years doing criminal defense and post-conviction work. She had overturned 4 wrongful convictions in her career before Maya walked into her office. She was not easily surprised and she was not easily moved. She had read the file Maya brought her in a single sitting on a Saturday morning with 2 cups of coffee. When she finished, she had called Maya and said 3 words. I am in. Her first move was the evidence warehouse. She filed a motion requesting access to the untested physical evidence from the original crime scene. The fingerprints, the fiber samples, everything that had been logged 18 years ago and never examined. The motion took 6 weeks to be granted. When Carol walked into that warehouse with a forensic specialist named Dr. James Okafor, no relation to the priest as it would happen, she found the evidence exactly where it had been logged, undisturbed, untouched, waiting. Dr. Okafor processed the fingerprint evidence over 4 days. What he found was a complete latent fingerprint on the interior door handle of Gerald Pope's car, a print that had been lifted at the scene, properly preserved, and never run through any database. He ran it. The result came back in 48 hours. The print did not belong to Marcus Webb. It belonged to a man named Curtis Ames, 51 years old, currently residing in a suburb of Milwaukee, Wisconsin, with a prior conviction for armed robbery from 26 years ago that had been served and completed before Gerald Pope's death. Carol sat with that result for 1 full day. Then she began building the second part of her case. Curtis Ames had not been difficult to find. He had lived a quiet, unremarkable life in the same Milwaukee suburb for the past 16 years, working as a maintenance supervisor at an apartment complex. He had a wife, 2 adult children, and a record of community involvement that his neighbors described as genuine and consistent. He attended church every Sunday. He had for the past 9 years attended the same Catholic parish, the parish of Father Daniel Okafor. Carol had not known about the confession when she found the fingerprint. She had gone to Milwaukee to interview Curtis Ames directly, a move that required careful legal preparation because approaching a potential suspect without triggering legal complications required precision. She had gone with a colleague and a digital recorder and had knocked on Curtis Ames's door on a Tuesday morning. He had answered. He had looked at her. And something had moved across his face, not guilt exactly, but recognition. The look of a man who has been carrying something for a very long time and has always known somewhere that it would eventually come to his door. He had said, "I need to call my attorney." Carol had said, "That is absolutely your right. I want you to know that I am not law enforcement. I represent Marcus Webb, and I have a fingerprint." Curtis Ames had stood in his doorway for a long moment. Then he had stepped back and said, "Come inside." What happened in the next 2 hours was not a confession. Curtis's attorney, reached by phone within 20 minutes of Carol's arrival, had instructed him firmly not to say anything substantive, and Curtis had complied. But in the spaces between the things he did not say, Carol had heard enough. She had heard a man who was tired, a man who had spent 18 years building a decent life over a foundation that was not decent, a man who went to church every Sunday, and had, 9 years ago, told a priest something that had not absolved him of anything except the solitary weight of it. She had gone directly from Curtis's house to the parish of Father Daniel Okafor. Father Okafor was 63 years old, a Nigerian-born priest who had served in the Chicago and Milwaukee areas for 30 years. He was a thoughtful, careful man who had, by his own account, spent 9 years in the most difficult spiritual struggle of his life. The seal of the confessional is one of the most absolute obligations in Catholic canon law. A priest cannot reveal the contents of a confession under any circumstances, including legal compulsion. Father Okafor had known this. He had also known every day of those 9 years that a man was sitting in a prison cell for something another man had confessed to him. He had prayed about it constantly. He had sought guidance from his bishop, framed in terms abstract enough that the seal was not broken. He had read every theological and legal analysis of the confessional seal he could find. And he had arrived, 9 years in, at a position that was not a violation of the seal, but was the closest thing to it that his conscience and his faith could support. He could not reveal the contents of the confession. But he could, he had concluded after 9 years, confirm that a confession had been made. He could provide an affidavit stating that he had received a confession relevant to the Gerald Pope case from an individual whose identity he could not disclose. He could state that the confession had contained specific details consistent with the crime that had not been made public. And he could state that in his professional and spiritual judgment, the confession had been genuine. He had been waiting. He told Carol for someone to come and ask him the right question. Carol had asked it. The affidavit Father Okafor signed that afternoon was 7 paragraphs long. It did not name Curtis Ames. It did not describe the specific contents of the confession, but it stated, with the full weight of a man who had spent 9 years weighing every word, that a genuine confession relevant to the murder of Gerald Pope had been received, that the confessor had demonstrated knowledge of the crime consistent with direct involvement, and that to Father Okafor's knowledge, the individual currently imprisoned for that crime had not been identified in the confession as the perpetrator. Carol had called Maya from the parking lot of the parish. She said, "We have everything." Maya had said, "What do we do now?" Carol said, "Now we go back to court. Subscribe to Sweet Justice right now." The post-conviction hearing that followed is the most extraordinary courtroom moment in this entire case, and we are just getting to it. The post-conviction relief hearing was scheduled for a Thursday morning in November, 18 years and 7 months after Marcus Webb had been convicted. Marcus had been transferred from the downstate facility to a holding cell in Chicago 2 days earlier. Carol had visited him the evening before the hearing. She had told him everything: the fingerprint, Curtis Ames, Father Okafor, the affidavit. She had told him that she could not promise the outcome, but that the evidence was the strongest. Post-conviction package she had assembled in 26 years of practice. Marcus had listened to all of it without interruption. When she finished, he had been quiet for a moment. Then he said, "Ms. Briggs, I have been telling people I did not do this for 18 years. I stopped expecting anyone to believe me a long time ago." He paused. "I'm going to need a minute to believe that someone actually found the proof." Carol had given him the minute. In the hearing, Carol presented the evidence in 3 stages. First, the fingerprint. Dr. James Okafor took the stand and walked Judge Ellis through the recovery, preservation, and analysis of the latent print. He explained the database match to Curtis Ames. He explained the statistical confidence level of the match, a figure so high that Gerald Fox, the state's attorney assigned to respond to the petition, did not challenge it. He simply noted it, for the record, and moved on, because there was nothing to challenge. Judge Ellis said, "Dr. Okafor, I want to be clear about what I'm hearing. Are you saying that a fingerprint recovered from inside the victim's vehicle at the original crime scene matches an individual who was never investigated in connection with this case?" Dr. Okafor said, "Yes, Your Honor. That is correct." Judge Ellis wrote something on the pad in front of him. He did not look up for a moment. Then he said, "Continue." Second, Carroll presented the evidence of the eyewitness identification procedure, the documentation showing that the photo array had been administered by a detective who knew which photograph was the suspect, in violation of protocols that the state of Illinois had adopted specifically to prevent unconscious suggestion. She presented an expert witness, a cognitive psychologist named Dr. Sarah Lowe, who had spent 30 years studying eyewitness reliability. Dr. Lowe testified that the identification of Marcus Webb had been conducted in a manner now understood, to significantly elevate the risk of misidentification, and that the specific conditions under which Patricia Dunn had made her identification, low light, brief observation, high stress, suggestive procedure, were precisely the conditions her field had documented as most likely to produce unreliable results. Gerald Fox cross-examined Dr. Lowe. He noted that the science had evolved significantly since the time of the original trial, and that the procedure used had been standard and accepted at the time. Dr. Lowe agreed that it had been standard. She said, "Standard and reliable are not the same thing. What we know now is that the standard was wrong." Fox had no follow-up. Third, Carroll presented Father Okafor's affidavit. She asked Father Okafor to take the stand to authenticate it and to answer questions about its contents within the boundaries of what his conscience and the law permitted him to say. Father Okafor entered the courtroom in his clerical collar and took the oath with the specific gravity of a man who understood exactly what he was doing and had decided after 9 years that it was the right thing. Gerald Fox stood immediately. He said, "Your Honor, the state objects to any testimony from this witness that touches on the contents of a sacramental confession. The confessional seal is recognized in Illinois law, and this court cannot compel." Judge Ellis raised one hand. He said, "Mr. Fox, I have read the affidavit. Father Okafor is not here to reveal the contents of any confession. He is here to authenticate a document he signed and to answer questions within the boundaries he has already established. Your objection is noted. It is overruled. Sit down." Fox sat. Carroll asked Father Okafor 3 questions. She asked whether he had signed the affidavit voluntarily and without coercion. He said yes. She asked whether the statements in the affidavit were true and accurate to the best of his knowledge. He said yes. She asked whether there was anything in the affidavit that he had included without being fully certain of its truth. He said no. He said, "Every word in that document is something I have been certain of for 9 years. I have simply been waiting for the right way to say it." Carroll said, "Nothing further." Gerald Fox approached for cross-examination. He stood before Father Okafor for a moment, then he said, "Father, you cannot tell this court who made the confession you are referring to, correct?" Father Okafor said, "Correct." Fox said, "And you cannot tell this court the specific details of what was said, correct?" Father Okafor said, "Correct." Fox said, "So what this court has is an affidavit from a priest saying that someone at some point told him something relevant to this case, without a name, without specifics. Is that a fair characterization?" Father Okafor looked at Gerald Fox for a moment. Then he said, "What this court has is the word of a man who has served God and this community for 30 years, who has no motive to be here except the weight of his own conscience, and who is telling you that the man in that prison cell is not the man who committed this crime. You may characterize that however you wish, counselor, but I would ask you to consider carefully what you are dismissing." The courtroom was completely still. Fox said, "No further questions?" He sat down. He did not look at Father Okafor again. Judge Ellis recessed the hearing for 48 hours to review the submissions. When he returned, he delivered his ruling from the bench in a statement that lasted 22 minutes and was, in the judgment of every attorney present, one of the most precise and unflinching pieces of judicial writing any of them had heard delivered aloud in a courtroom. He said the fingerprint evidence alone was sufficient to establish a substantial question about the reliability of the original conviction. He said the eyewitness identification evidence compounded that question significantly. He said that Father Okafor's affidavit, while it could not be treated as direct evidence of another perpetrator, was consistent with the physical evidence, and added a dimension of credibility to the petition that the state had not meaningfully rebutted. He said that taken together, the three elements of the petition met the standard for post-conviction relief under Illinois law by a margin he described as, and he paused here, not close. He said, "The conviction of Marcus Webb is vacated. The case is remanded for further proceedings consistent with this ruling. Mr. Webb is to be released from custody pending those proceedings, effective immediately." The sound that came from the gallery was not cheering. It was something more complicated than cheering. A long, collective exhale, the sound of a room full of people releasing something they had been holding since the hearing began. Maya Chu, seated in the third row, pressed both hands over her face. The journalist in the back row, the one who had covered hundreds of hearings and prided himself on neutrality, wrote 3 words in his notebook and then stopped writing and simply sat. Marcus. Webb stood in the courtroom in a gray suit Carol had brought him the previous evening, his own clothes chosen for this day. He was 40 years old. He had been 22 when they took him. He looked at Carol, and Carol looked at him, and neither of them said anything for a moment. Then Marcus said, "Can we go?" Carol said, "Yes, we can go." Curtis Ames was indicted, 4 months after the hearing, based on the fingerprint evidence and a subsequent investigation that produced additional corroborating findings. He entered a guilty plea before the case reached trial. He was sentenced to 22 years in prison. He was 62 years old at sentencing. Patricia Dunn, the eyewitness whose identification had placed Marcus Webb at the scene, gave a statement to a reporter 2 months after the hearing. She said she had been certain. She said she had never doubted herself. She said she still did not fully understand how she could have been so certain of something that was not true. She said, "I have thought about this every day since I heard the news. I don't know what else to say except that I am sorry. I know that is not enough. I know that will never be enough." Marcus Webb settled a civil lawsuit against the state of Illinois for an undisclosed amount 2 years after his release. He enrolled in college at the age of 42. He has not spoken publicly about what he wants to do next. He has said only that he is interested in the law. Maya Chu graduated the following spring with honors. Her professor submitted her original paper for a National Undergraduate Research Award. She won it. At the award ceremony, she was asked what had drawn her to the Marcus Webb case, specifically out of the 10 files she had pulled that Tuesday afternoon. She said, "I don't know. Something in the file felt wrong. I just kept reading." Carol Briggs returned to her office the Monday after the hearing and began reviewing the next case in her queue. She has not given interviews about the Webb case. She has said only, when asked, that she did her job. When pressed on what made the difference, what allowed her to find in 11 months what no one else had found in 18 years, she said one thing: "I read everything. I tested everything. I did not assume that because something had been missed, it was not there to be found. That is what this work requires. You read everything, and you do not stop. That is what happens when you hire the right attorney for the job. Not magic, not luck. 26 years of doing the work, reading everything, and refusing to stop. This is sweet justice. Subscribe to our channel for new courtroom stories every day. Share this with someone who needs to be reminded that the truth can still be found, even after 18 years. Hit that bell and stay with us. We will see you very soon.